I would like to welcome Mr. Philip Furgang to the National IP Yatra program being organized by Ministry of MSME at Hyderabad in India. Mr. Philip Furgang is a very senior IP attorney. He is a US attorney and he is also founding partner of Furgang and Adwar Ivko. And he is a newer super lawyer for IP law for most of the year since 2019. That this is an honor awarded by his peers, those working in the IP attorney, those who are IP attorneys, to less than 5% of all lawyers. So Mr. Philip Furgang is going to present his expertise, his insights into IP commercialization and globalization. So please welcome him with a round of applause. Thank you so much for joining us. It's all yours now. If you have a presentation, you can share it. If you have the rights to share it, if you don't have it, we will get it granted. Okay, sir, all yours.
I begin.
Yes, thank you.
Well, good day, all. And I'm communicating from days. There is a time delay. It's a little difficult, but let's try. Okay. Please understand that I am not it's very difficult to talk because I'm getting feedback, but let's try. Talking here today about utility patents and design patents and their usefulness in securing rights for your businesses in the U.S. First, you should know that all of the intellectual property rights that we talk about emanate from a single source. In the medieval time in Italy, there was an architect, builder named L.L.C, who was asked by the prince of one of the states in Italy to design that he had to retain the rights to the dome. In other words, if somebody wanted to copy and build that dome, Mr. Brunelleschi wanted to profit from that. Today, that's not an unusual experience, but then it was completely new. But the prince said, all right, I'll grant you a property right, and that was the first patent ever granted. Now, a lot has happened since then, and I'm not going to dwell on what has occurred since then, but just simply to point out that in the United States, a utility patent is just what it sounds like. It is the utilitarian aspect of an invention, how something works. And the rights controlled by a utility patent enable you to control, or the patent owner to control, whoever makes, uses, or sells the inventive device. This is to be compared with and differentiated from a design patent. A design patent covers a non-functional ornamental feature. For example, if you had a vase and you put on the vase a bluebird, a drawing of a bluebird, you could get a design patent on that. It's considered a utilitarian function. Now that is distinguished from copyright, where copyright is more focused on the actual item itself, like a play or a story. Generally speaking, design patents are free for devices, or for example, like a curtain rod, for example, could be a design patent. The non-functional features of essentially a utilitarian device. Both have uses for you in your businesses. When you go to apply for a patent in the United States, one of your major concerns is obviously the cost that you're going to have to apply, or use rather, to obtain these rights. And the utility patent is far more expensive than a design patent. And it's much more complex in securing it. In the design application, what the examiner does is the examiner looks at similar designs on file with the patent office and then decides whether or not that design is unique, different from the design that they see in their archives. For a utility patent, the test is different. Utility patent, you're going to look for it, two principal tests. Has it been anticipated? Meaning, here is your device, and here is the inventive device. They look the same, it's anticipated. Or is it obvious, which is a much more sophisticated test. The obviousness test says, you look at the invention, and you see whether or not the invention was simply one that one would have arrived at by looking at the prior art. Now, that sounds very vague, and it is, because that's what it is. And most of the disputes are arising out of inventions that are sought to be patented usually comes down to arguments over whether it has been obvious in view of the prior art. And the scope of patent rights are entirely different between a utility patent and a design. The design is design. And if you look at a U.S. utility design patent, it simply says, the claim reads that you are claiming the invention of the design shown in the drawing of the patent as issued. Whereas a utility describes how it's put together, how it functions, and also includes, of course, the aspect of the drawing. So it's a much more sophisticated and different test. The design patent in the U.S. will last, I would have to check, but I think it's 12 or 14 years in that range. The utility patent will last 20 years, so it's a longer period of time. And if you file based on what is called a provisional application, that is an application filed without claims, just filing the description of the invention. Once you file the utility patent, which you must do within a year, you will have 21 years from your original filing date. Coming from another country, as you do, you will undoubtedly be filing without a provisional. You could do that. You're not precluded. You could file directly and file a provisional, but most likely you would file with your Indian attorney. You will file through either directly or through what is called the Patent Cooperation Treaty. And if you do that, you have 20 years from the date you file and once it issues. Now, a couple of cautionary notes. If you disclose your invention, this is true of either a design or a utility patent. If you go on and disclose it to third parties before you file, you will be precluded from filing. So you've got to keep it within the confines of your business and not be showing it to other people. Now, suppose you said, well, I need financing. to prepare and file a patent application. How do you expect me to obtain a patent if I don't get the financing? This stuff is not inexpensive. Well, in that regard, you have your attorney prepare what is called a non-disclosure agreement, or NDA, or confidentiality agreement. They're all the same. And which the party receiving the information agrees to receive it in confidence and not disclose it. And that will in no way affect your rights to file any place, because you now have that agreement with the person for whom you're showing. Excuse me. Now, by the way, while I'm addressing any of these issues, you have a question, by all means let me know and I'll address it immediately, rather than going on, because it might get rather confusing. Now, can you file a design patent on, or should you file a design patent on a utilitarian device? Remember that I said that design patent covers the ornamental feature of an article of manufacture. So the issue is, I'm going to file my patent application in your country, but I don't have the financial resources to file the utility. Is there a choice? Yes, there is. If what you're looking for is to mark your device being sold in the U.S. patent pending, this label that you put on, you can only put on the device if you have an application pending in the patent office. Well, can you put it on a device and you don't want to spend all that money on it, you don't feel it's worth the expenditure, but you want to use patent pending? Can you do that? Yes, you can. And here's how you do it. You take your device and you put a decorative design on it, and you have the U.S. attorney file a design application. In fact, when you file the design application, you file multiple designs, not just the design on your device, but other designs that you could equally put on it. And then what you do is you file that patent application, and it will be pending for as long as some design in that application is before the patent office. And you are permitted, so long as your original design remains in the application, hasn't been examined or is being examined, but has not been abandoned in any way, you can continue to use the expression patent pending. That's a very inexpensive, relatively inexpensive way of doing things. It has a downside, and the downside is you don't have any enforceable rights. What you have is patent pending, but you have nothing to enforce. Why would you do that? Because from your financial point of view, patent pending is more important than getting an actual patent. Okay, now let's return to the utility application. Your right to file, you have a right to file, you file. And by the way, you would have to file before your invention is published in your country, for example, as an Indian patent. And now you want to file in the United States, you must do so either based on the filing date of the original application in your country, in which you have 1 year in which to file in the United States, or you can file at any time so long as it's pending and has not been published in your country. Okay? Now, the utility patent is complex because you're measuring it against anticipation and publication. Now, what else can I tell you about this that would meet your needs? Yes, the marking of an invention to say it's patent pending enables you to warn off competitors in the United States that says you have a potential patent right. Now let's talk about for a moment what happens if you have filed for a utility patent in the United States and suddenly a competitor ignores the patent pending and copies it. Comes out and in competition. What can you do? Your application is pending. What can you do about that? Well, here's what you can do. In the United States Patent Office, under our laws, you have the right to have your patent moved up in what is called expedited examination. And one of the reasons you can put forward is have a competitor that's infringing and I want to go to court. And the patent office will move it up for you. Now, the alternative is another way, by the way, there's another reason you can get to issue your patent quickly, and that is one of financial reasons or age. So if you are an inventor and you're a senior citizen, you have every right to have that invention moved up quickly to issue as quickly as possible. That also applies to a design application, but why you want to prolong, why you want to issue a design patent quickly is not immediately obvious. Let's see. All right, now what is the utility application comprise? Well, it comprises three parts. A drawing, which shows the invention. Is a drawing absolutely necessary in all cases? No. If we're talking about a chemical formulation, there's no drawing required because there's no drawing available. But if we're talking about mechanical or electrical, going to be required to provide a drawing. The drawing would start with a sketch by you, and then the drawing would be submitted to a draftsman. Most often, that would happen at your end with your Indian attorney who would prepare an application under your laws and then would provide it, that attorney would then provide it to his attorney in the United States. When we receive it, we would make sure that the drawing comports with the requirements of the United States Patent and Trademark Office, and most importantly, we would also then, we would have to include with that drawing a complete description. And the specification is broken down into several parts. It's not something we just write off the top of our head. We're told what the application must include. Excuse me. So here we have an application must have specification that details every aspect of the invention. If you were to read it, it would be, first of all, it can be very detailed, like a manual, telling the person reading it how you would make and use that invention. If it was not completely described, you would not get your patent. The second thing that you would want the application would also include would be a series of statements at the end of the claim, at the patent called the claims. Now, historically, if you looked at a deed in the United States, its structure is very similar to the claims in the United States for a patent, in that it's one sentence in length, and it's a series of statements, such as a device comprising And then the attorney will list the various aspects of the invention just as if he were constructing it. And the claims would have to be set up in a way that you go from broad statements about the invention and then add in various details, getting the claims narrower and narrower and narrower. Why would you do that? Why would the attorney in the United States do that, or the attorney in India do that? Well, you do that because you're trying to avoid a competitor signing a device that gets around your invention. Okay? Now, just to backtrack a bit, when we talk about showing your invention to, say, potential investors or potential licensees, and I'll get into that in a minute. But when you do that, your non-disclosure agreement or confidentiality agreement must have in there limitations on what can be done with the information you're provided. In other words, it's not merely that they're going to hold it in confidence. You want to make sure that that agreement says they're not going to use your invention without entering a further agreement with you. Why? Because otherwise you're giving your competitor a gift to take your invention, and then, since there's no immediate apparent patent involved, or even if there is one, work around it. So you need your confidentiality agreement to cover all of that aspect of it. Okay, now what happens when your patent is filed as a utility patent in the United States? What's going to happen? There is a series of examination statements. In other words, what happens is the patent application will be assigned to an examiner. The examiner will then issue what is called an office action. And in the office action, the examiner is going to more than likely issue objections to the issuance of the patent. Now, why is the examiner doing that? Because the examiner's function is to serve as a gatekeeper. The examiner's function is to make sure that if a patent is issued, that patent will differ from what the claims of that patent will be different from what has been done before. That is, it will not be anticipated and it will not be obvious. And the language used in those claims is critical. You have as a patent owner, have to be in a position to be able to enforce it against actual or potential competitors during a patent life. And if you're not in that position, if you're not getting what you want, you are going to be losing not only your invention, but a lot of money. So you want to know that when you get this proposed patent language, that not only covers your invention, but is broadly stated, at least in the broadest claims, so that competitors cannot come in and do something very similar to yours, using your inventive idea. Now you notice I haven't gone into this detail in a design application, because it's just a design application. It's merely visual, non-functional, and it doesn't cover the same thing as I said before. Are there design applications which are valuable? Yes, of course there are. But the major part of value in the patent system resides in the utility patent rights. Okay, now, what do you do? Let's assume you get your patent issued in the United States. What do you do if an infringer comes upon the scene? Well, you should act promptly to tell that infringer to stop, or else or you can be opening to licensing your inventive rights to a potential or actual infringer, or just to some business that would like to use your invention. So let's talk about licensing of these rights. Can you license a design application? Absolutely. And there are designs which are very valuable. A part of the utilitarian, the non-utilitarian designs, but they're very attractive to the public. They allow you to sell devices or items that have these shapes or designs, and you can do that as well. But I'm going to focus on the utility aspect of this, because that's the most likely item that you do that. How would you go about licensing that in the United States? Well, the first thing you need to do is to identify all potential licensees. How do you find them? Well, I'm sure you're all familiar with Google, right? And if you're familiar with Google, what you do, or like search engines, you would go on there and search for your competitors. Usually, in most instances, you'll know one or two competitors right now because they're selling in India. But even if you don't, you would go for it and you would attempt to identify licensees by simply going into a search engine and putting in the principal aspects of your invention, not everything, but the principal aspects of your invention, and you would ask the search engine, who sells this? And up will come the names of potential licensees or competitors, and those would be people you would contact. How do you contact them? Simple enough, write them a letter. Who would you write to? Well, the best way of doing this is to write to the companies that are involved, but by doing so, you might want to first contact them. And by the way, you could do this directly yourself, or you could do it through your attorneys, or your U.S. attorneys, but the least expensive way of doing this for you would be for you to do it yourself. What you must do is remember, we'll go back to that non-disclosure agreement. You're not going to disclose anything more about the invention, just a general indication of the invention, and would they be interested in licensing. Now, excuse me. How would you go about licensing that then? What would you do? Well, your first letter to a potential licensee would be to introduce the invention generally, without getting into great detail. Why would you do that? Because you're only interested in talking to people who would want to take a license, who would want to enter a license with you. If you're going to do that, your first letter just merely indicates, I have a device I want to license you on that you would be interested in using. Are you open to entering into a license agreement? Many companies throughout the world will have a position that they don't want to take a license, that they're not interested, and you don't want to communicate your invention to them because it doesn't serve any purpose to you and it doesn't result in any money in your pocket. So you first want that's your first letter. And then your second letter to the competitor or the potential licensee, excuse me. Your second letter would then say, we'll give more details, would then provide a confidentiality agreement again, and then would provide some of the details, but not all of it, to them to see if they are interested in moving forward with the licensing negotiation. Why have a second letter that doesn't get into a lot of detail? Again, because you want to eliminate those who are not going to be really interested in entering a license agreement. And then your third letter, the most important letter, of course, after the non-disclosure agreement, and that letter will include not only a copy of your patent application, but don't include the claims. Why wouldn't you include the claims? Because you don't want the potential competitor or licensee to see the claims at this point and work around your invention. You just want them to see the description, the full description of the invention that is in the specification. So you send that to the potential licensee, and then the negotiations would begin. And at that point, the potential licensee would say to you, we've got to see the claims. And that is not unreasonable, because they would want their attorney to review the claims and see exactly what they can and cannot do under your invention. Now, let me pause here for a moment and go back again to the original filing. I'm not acquainted with Indian patents. I am acquainted with U.S. patents. If you have not had a patent novelty search done in your country before you filed your patent in your country, it would be wise to have one done in the United States. If you, on the other hand, have had your attorney has performed a patent novelty study to see if the invention is novel, that would be, that's valuable to you in terms of the prosecution, and that information will be provided by your attorney to the U.S. attorney. Now let's go back to the licensing. We are in licensing mode, and then you would get into negotiations. Okay. What should you be demanding from your licensee? Well, you obviously want a percentage of the sale price of the item being licensed. How much do you ask for? And this can be tricky. If you come into somebody and you want an exorbitant amount of money, that will be the end of the licensing negotiation. If you appear to be asking for too much, the licensee is going to say, forget this, it's not worth it. If you ask for too little, you're hurting yourself. You're not getting all of the money that you're entitled to. So how much should you ask for? Question. And the answer is, neither the attorney nor you are going to know that answer. But there is a way of finding out. There are services that will provide you the percentages of necessary for licensing a product, a patent. And where does this information come from? Well, these services keep an eye on proceedings in courts. Why proceeding in courts? Because in a litigation, the people enforcing their rights to similar or related inventions to you, that is similar or related to your invention, those people are going to be claiming damages, and courts are going to be awarding damages. And what are the damages going to be awarded? It's a percentage of the sales done by the infringer. So they collect that information because that is essentially licensing fee and by a court. Also, there are articles written, and also many corporations file in the United States, especially U.S. corporations, file what is called an EDGAR notification to the Securities and Exchange Commission. And in that, they will specify that they have entered licensing agreements with third parties, and this is the royalties that they're paying. So they collect all of that information, and when we come forward to them with your invention, present that to the companies that provide this information, and they'll come back and tell you what percentage is usually taken as a licensing fee. With that information, you know how much to ask for. You're obviously going to ask for on the high side. Why? Because you want to negotiate. you don't want to start too low, but you do want to be a little bit on the high side to then negotiate the contract with them. And what will you do with that? What will the license include? Well, of course the license is going to include that you're licensing them under this patent, but you can put other restrictions on them. For example, suppose you have an ongoing business in India. You don't want this licensee to be selling your device in competition with you. So you may want to provide the license agreement that says you don't come and you don't sell in India. Or suppose you have an ongoing export business where you're selling your device and you're exporting to France, to China, or wherever else, and you want to be able to keep the licensed competitor out of those markets. That would be one of the things that you would put in the license agreement. Now, another aspect of these licensing is litigation. Typically, when you are the licensee of your invention, somebody else, the licensee is going to look on you to enforce the patent rights. Meaning that if you get into an infringement situation with somebody, a competitor, say in the United States, they're going to insist that you undertake the litigation. And that's something you have to be very concerned about. Because if you go into litigation, and I'll speak only about the United States here, it is very, very, very expensive. And so you would only want to do that if your device had such sales as made it worthwhile. That doesn't mean you can't enforce your rights. It doesn't mean because it's expense for you, it's also expense for the other side. So it doesn't mean you wouldn't write to the other side and say, if you don't stop this, we're going to sue you, a cease and desist letter, even though ultimately you might not litigate because it's not worth it to you. But you're talking about a lot of money involved. Now, at this juncture, I would be happy to answer some questions for you and go into further details on any of the points that I've raised before I move on to other areas. Are there any questions?
Yes, so
Go ahead.
yes. So one question from the participant here.
Respected Furgang ji.
All right, I'm having a problem at my end. I'm not hearing you. Hold on a second, please. Now I have the audio. Go ahead.
Thank you, respected Philip Furgang ji. You have given a very good interaction on US patent. Myself, Ravi Kishore, Indian patent granted in the year 2017, and the same patent have been filed in USPTO in the year 2018 itself through PCT norms. So what all the guidelines you have given to us is very much informative to our MSME entrepreneurs. We are very much thankful for MSME National IP Yatra, and indeed you have given a very crispy presentation which is very interactive for our entrepreneurs. And coming to the questions what you have given, once we have given a patent has been filed in the year 2018 and multiple times all the claims, interviews have been taken with the concerned examiner in USPTO, and now it has come to a stage of notice of allowance, and we have given self-declaration also as requested by the examiner. So at this junction of time, now new references have been cited from final office order, it has come into non-final office action. So in this regard, I will definitely share my application details.
See, it's the audio. I'm having particular understanding what you're saying. Could the moderator or someone repeat the question for me, please?
Okay, it is a notice of allowance have been come to the stage of USPTO, one of my patent application. It's almost in the final stage of grant. But it has took 8 years to come up to this stage where Indian patent is granted within a span of 1.5 years with a national award received from our Prime Minister. But here the notice of allowance stage has come, but it has been kept in withheld. So I will send you all the application details personally to your mail ID. You can go through the application and definitely I will connect in your personal window, please. 8 years time it has been taken. For a normal patent of US, what is the time guidelines for the grant?
So, US PTO office, it's an ordinary patent application. So how much time it takes on an average for the patent to be granted?
I'm not hearing the
Yes. So, am I audible now? Is it audible? Are you able to get my voice? My audio over there?
It's an echo and it's
Okay.
very hard to understand you. Apologize.
Yes, am I audible now? Is my audio reaching you? Yes, am I audible now? Am I audible?
Oh,
Yes, so I'm audible now? Is my voice reaching you?
yes, I can hear you better now, yeah.
Okay. The question is, while the Indian patent was granted in 1.5 years, the US PTO patent application almost 8 years not granted yet. So, we would like to know from you how much on an average US office takes, for the granting of the patent. On an average, how much?
Okay. Let's see, let me repeat back to you, so I'm sure I'm responding to your question. You're asking me how long does it take for a patent application to be examined in the United States? And you indicated, I think you said it's been pending about 8 years.
Yes, that is correct.
Okay, good. The general pendency of patent applications until very recently was about 3 years. It could be shorter, and of course it could be longer. I'll answer your question directly, then I'm going to get into some additional matters that you should know about. But specifically on your point, 8 years appears to be a much longer period of time. Now, I will tell you this, the current political administration in the United States has taken some steps which are very, very bad for patent owners. And patent applicants, in that they're cutting funds all across the board in all of their administrative agencies, and that has caused delays. But 8 years is a very long time and extraordinary. You might have your attorney contact the patent examiner or the patent examiner's supervisor to find out what is holding up matters. That, while it's unusual, it does happen that you get delays, that files are misplaced, or examiners make errors in addressing applications. So you'd want your attorney to contact, the U.S. attorney to contact the patent office or report back to you exactly what is causing the delay and what can be done to move it forward.
Yes, thank you so much. there are some cases, where the US patent is granted earlier than the Indian patent. It is pending in the Indian patent office, but the US patent is already granted. So that is also there, and sometimes in Indian office also we have, some patents are pending long time. So there is another question which I have. There is something called as a terminal disclaimer form. A terminal disclaimer form,
Yeah.
which I see. So can you explain about that, and whether it is mandatory, what is the purpose of that?
A terminal disclaimer is where you actually are called upon to disclaim part of your invention, that you don't seek patent rights in a particular area. And why would they do that? That is to assist them in the examination process, so that there are, let's say, alternatives A, B, C, and D, and they want you to disclaim C and D, but you're not seeking the rights for those particular areas. That's got to be approached very carefully, because when you expressly give up rights, that can affect the enforcement of what the patent that issues. And in fact, I'll digest a little bit there. During the prosecution of your application, the statements made by your attorney in the United States to the patent office can be used if you get into litigation where the defendant, the putative infringer, argues during the prosecution of the application, you, that is your attorney, said to the patent office, such and such and such and such, and that's what we're doing, and we're not doing what you claim. So the language used, what the attorney writes to the patent office, is very critical and must be watched very carefully. And if you get a communication from a U.S. attorney through your attorney that says we've done, or you go directly to a U.S. attorney, and you see the statements that have been filed while the application is pending, and you have a question about it, you follow that up very closely and insist upon understanding what that amendment means and what it says. And if you have you read it and you have a different interpretation of it, that's okay. You come back to that attorney and say, I want to know what this means and what the result is going to be. Can my competitor do this or that, and will my claims cover that? It's always an important, valuable conversation to have. Filing a patent in the United States is not simply, I give it to an attorney and the attorney will do it. That's a mistake. You must always be in hands-on communication with the attorney, either through your Indian attorney or if you're doing it directly through the U.S. attorney, so that you know exactly what's happening. Too often, attorneys will look for a way to get the patent issued, but from your vantage point, as the inventor or the company that has the invention, you want to be sure that you're not losing rights to which you are otherwise entitled. Your individual awareness and understanding of what's going on is very important. Did I answer your question?
Yes, sir. Thank you so much, for explaining that. I was until now thinking that you have the claim being drafted, so everything is mentioned in the claim, but we also have another option, terminal disclaimer form. So with respect to the previous question, the patent application at the USPTO office, which was pending for 8 years, has been converted to a pro se applicant. Now, from the attorney, US attorney has been converted to a pro se applicant.
The second again, please.
patent for his invention in India, and he started his converted invention into a product, and he wants to export the product to US from India. So he still needs a patent in the USA to export it, or if not, can someone in the USA copy the product and patent it in USA?
First of all, that's a very good question. First of all, so let me repeat back the question being asked so we're all on the same page. You're saying you have a patent application in India, somebody sees it, and they go off and file their own patent application. Can they file? Yes. Should they get a patent on it? Well, if you can always either protest it directly to the patent office if you're aware of it, which is unlikely. But if you find that in the marketplace, this guy says, I've got a patent, and it's your invention, and not only that, but he acquired that information from you, he is not the inventor. The law requires in the United States that only the inventor or what we call the person who purchased those rights from the inventor, that is by an assignment. The expression is an assignee. That only that individual can apply. So if you're the inventor and you have not sold that invention to anybody, and the most you have done, say, is licensed, no third party can come in, take your invention, and legitimately file an application, maintain those rights against your claims. And I in fact, have had cases like that. I've lost your picture. Can you still hear me? Hello?
Yes, we can hear you. Yes. This is our picture.
Good.
We have been hearing your audio is clear.
Okay, that's fine. I don't need a picture. I just wanted to make sure because I got this picture up, not of the audio. Okay, so effectively, the straight answer is no one can apply for your invention and by taking it from you. That's not permitted. On the other hand, there's another aspect of this. Suppose Mr. Smith, if you will, at a time in the United States, we used to have a proceeding called an interference, in which competing owners of the same inventor would have to establish who invented it first. Since 1997 in the United States, that has not been the law. Instead, the rights will go to the first to file. Who's the first to file? Well, if you're filing in India and then file in the United States, your first to file is, and you base it on an Indian patent application, your Indian filing date is your first to file. If you file directly, it'll be without filing an Indian patent, or filing directly without relying on it. It will be your U.S. filing date. If somebody else gets to your invention, files. Now, suppose you went to a competitor or a possible business that would not directly compete but want to take a license from you, or you thought they did, and you disclose the invention. Remember that non-disclosure agreement? Well, the courts would require that individual to turn over their rights to you. Because they're not permitted. Only the inventor or the inventor's first inventor signs to has the right to that patent. Answer your question.
Yes. Also, you have said like other things as well. So I think we we don't have any more questions from the audience, I would like to thank you for joining us. I know it is early morning in the US and it is around 6 p.m. in the evening in India. I think around 8 o'clock in the morning in US. And
Right now it's 8:42 a.m. in the United States.
Okay, so thank you so much. You have given insights about utility patent, design patent and the differences, a strategy of patent pending for attracting investment, and then expediting examination in case of infringement in the patent pending, then drafting patent, how to draft it from broader case to narrow case, licensing strategies, what and how much to disclose in during negotiations, then to get the value of your invention, of your patent, to use examples from proceedings in the course of similar or related inventions. And I think it is Adwar you mentioned, right? The information you share with Securities and Exchange. Is it called Adwar? The information you sent?
Sorry, I didn't catch that. Could you say that again?
Yes, I think that is in US law, you have to share, the company needs to share information to notify the Securities and Exchange. So you can...
No, you don't have to. That information with regards to the securities exchange is what you're doing when you're looking for reasonable royalty rates that you would want to demand. You don't have to share your invention. For example, I'll just make something up. You have a new and improved a gun, a firearm. If you want to know what to ask for. You're not obligated to do this, by the way. There's no obligation for you to have your attorney or the U.S. attorney do this study for you as to what is a reasonable royalty rate. It is conceivable that you know what a reasonable royalty rate is. For example, you're a manufacturer in India and you have been under license on a different invention. You'll know what reasonable royalty rates are. So, but what I'm recommending is that before you would go through the process of licensing, to find out what a reasonable ongoing royalty rate is. Okay? Another point that I didn't emphasize when I was going through that is, remember I indicated that when you're the owner of the invention and you're licensing it, it's not unusual for the licensee to demand that you defend this patent in the courts. It also is in your interest to make sure that your licensee has the obligation of informing you of competitors with similar devices. Just because a competitor demands that your licensee demands that you come in and litigate, doesn't mean that you should do it. A competitor may not, a licensee may not like the fact that a competitor is selling a similar gun, but your patent may not apply to that. The licensee may want the use of the patent as a weapon against the licensee, against the competitor to try to force it out of business. Don't get into that because that's an enormous expense and it's not in your interest. You need an obligation in the license agreement. Report to me anything that looks like an infringement. And then you and your attorneys decide whether this is something you're going to proceed with.
So thank you so much for sharing real practical insights, which you will not find in books. These are practical insights you shared about when you file design or utility patents and licensing. And thank you so much for joining with us.
We'll add one thing more. If anyone in the audience today has a question that they didn't quite come up with at the time, and then occurs to them after we conclude now, by all means, contact me, and I'm sure your mediator can, or your people there will tell you how to contact me. And I will be glad to respond in a general way, not as to a specific matter, you know, that would require a fee. But if you have a general question of how the system works, what steps I can generally provide, contact me, I'll be glad to respond.
So we have few members in the audience who have already asked your contact details, email ID and phone number, you know, who would require, you know,
Okay.
so,
Okay.
yes,
Problem.
yeah, thank you so much.
Have a good one. Yeah.
Yes.
Okay.
Okay, we'll see you there. Bye.
Okay. Bye-bye.